And remember, this isn't just a murder trial. This is a RICO trial. So one of the things you have to prove up is an organization and acts in furtherance of the organization. When you have these lyrics, if they kind of establish who YSL is and they talk about who YSL is in these lyrics and different activities of YSL, there you go. I sort of agree with the defense on this in the sense that rap lyrics, especially like drill and maybe these kind of lyrics, are considered inflammatory. And you get some little old white housewife from the suburbs, and she starts hearing talk about pushing your shit back, boy, and, whatever the lyrics are going to be. And if they're murderous lyrics, talking about your ops, I think it would shock the conscience of anybody who is not used to hearing this kind of stuff.
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your personal board-certified criminal defense lawyer, accompanied by our content genius. And I'm coming to you with my pearl handle pistol cufflink, so graciously given to me by Michael Rivers, our content genius. He's behind the camera, behind the ideas, behind everything I stand for. Today we're reacting to an update of the YSL case. Now let's just kind of revamp of where this case came from and where it's at now. YSL is Young Slime Life, which is just a lovely name for a gang or a record label, for whatever you think it is. RICO case started more than 6 months ago. It is the longest jury selection process in Georgia history. The judge has been reviewing hardship over 2,000 jurors. What the hell? 2,000 jurors. It's going to be a long trial. But guess what it's not going to be? It's not going to be a trial with 28 defendants like it started out. They're down to about 8 people. And what does that mean? That means people have taken a deal. That means that there's probably a lot more snitches. But before we get to the meat of what we're going to talk about, this is brought to you by eSign.com. eSign.com, very effective way to remotely do business. Let's say your grandma's in your basement, right? And she's actually part of the YSL crew. But she's so well known, she can't go out in public. But she needs to get a lawyer because she's now a newly named co-conspirator. Well, what does your grandma do? Your grandma calls a lawyer who's downloaded the app, has 3 free signatures a month. She gets a retainer agreement signed with this new lawyer, and now she's good to go. I use it all the time. eSign.com, a very effective way to remotely do business. Because you know why? Because if it's not eSign, no one signs. So eSign.com. And here's the thing. Go to our sponsors. Whatever our sponsors are, we really appreciate that. There's been a real dust-up over 2 main issues, 2 really, really big issues. One, the prosecutor hiding the ball on certain witnesses and evidence that they are gathering. It's very, this case has been going on for a long, long time. The investigation has been going on for a long, long time. And the last thing the judge needs before a trial is what? Surprises. Last-minute surprises, last-minute witnesses, unfair opportunity to investigate something from the defense perspective is something that the judge is not going to tolerate. Let's see what the judge had to say.
Really, I'm really annoyed about this, Ms. Hilton. I just am.
I'm really annoyed. When the judge says he's really annoyed, you don't want to be on the receiving end of that. Believe me, I've been on the receiving end of that before.
This is ridiculous. Your witness list has grown by 2/3 since then. And I don't know why. You better have a dang good explanation on the 16th. Because if you don't, I'm going to exclude it.
I think what the judge is saying, you better not be hiding the ball anymore. Because if you don't have a good reason for this these late disclosures, whatever's late, I'm not going to allow it. And that's the remedy for it, right? So if you can't have that evidence in court, guess what? Whatever theory you were trying to prove through that witness is now gone.
Okay. But right now I'm telling you, without anything further, it's gone.
Well, we would like
to exclude a lot more on that date because this is ridiculous. There is no plausible explanation I've gotten and that would suffice that we just kind of keep, you keep dripping and drabbing out evidence.
What's frustrating that from a defense perspective is you're going down a path. You've investigated this case. You're putting your heart and soul into every little thing. All of a sudden, they come in last minute with something, and you get a report that's like 6 months old or 8 months old. It's like, wait the fuck minute. You were supposed to give this to me a long time ago. Judge isn't going to have it.
Well, we'll be asked to be heard on the 16th, Your Honor, and we'll have all the explanations for the court.
I'm telling you, it better be a good explanation, and if it's not, I'm going to exclude it. I'm just going to tell you that right now.
And that's the remedy. The remedy is that you can't have it. So and so we'll see what happens on the 16th with that. But here's another issue. So the judge has also just ruled that they can use the lyrics of his songs in the trial. This has been a huge controversial issue over the country in a lot of different cases. And I had that issue in one of my cases last year, and I kept it out. Let's see what the judge has to say about it, then we'll talk about it on the other side.
Let me go ahead and like I said, when we recessed last night, courts had an opportunity to ponder the issues that were presented yesterday in terms of the admission of lyrics or the exclusion thereof. So
let's just talk about that just generally for a second. Why would lyrics of a song be admitted into evidence? If it's off, well, first of all, it's a statement of a party opponent, so it's not hearsay, but it has to be relevant to something that's in the trial, material to a fact that's in the trial, and it can't be more prejudicial than probative. So those are your kind of guideposts.
to that extent, the court has considered the state's motion in limine to admit evidence of lyrics.
And a motion in limine, just so you know, is just a motion that's heard outside the presence of a jury. So it's a pretrial motion, and you want a pretrial ruling so you know how to try your case. That's all it is.
The opposition to the state's second supplemental, and motion in limine to admit evidence of lyrics at trial filed by, and on behalf of Mr. Kendrick, and argued by Mr. Weinstein, as well as Jeffrey Williams' motion in limine number 2, 1, and 2 to motion to strike, as well as Mr. Shart's oral motion, and the court will also consider it for any other lyrics that may be.
So what he's really saying there is, okay, the state filed their motion in limine. There's a motion in limine filed by the defense plus a responsive motion. So you got motions going back and forth.
Sought to be admissible in the trial of this matter. Specifically, I have considered the arguments of the state as well as the arguments of the defense. I'll kind of.
This is interesting because this is a fairly new area of law. A lot of people say, "Oh, you wouldn't have Johnny Cash's song lyrics," but if they're talking about ops in any of their songs, and there's a dead guy, and there might be some facts in the song. That's, what do we call that? Self-snitching.
The state has argued that this particular gang lyrics or evidence is admissible for several reasons. One, to show actus reus or mens rea, or other offenses under 16-14-4, 16-15-4, or 24-8-801 D2 alpha, 28-8-801.
Those are all, it's kind of arduous to listen to this, but those are all rules of evidence, and they're talking about hearsay exceptions.
That use of these particular, the admission and use of lyrics, poetry, or artistry against Mr. Williams or any of the other named defendants as appropriate in this upcoming trial would be a constitutional violation, abuse of discretion, too prejudicial and unconstitutional based on the provisions of the U.S. Constitution as well as the Georgia Constitution, and that moreover, using these lyrics, poetry, artistry, speech against Mr. Williams and others would be racist and discriminatory because the jury would be poisoned, prejudiced by these lyrics, poetry, artistry, speech as the same as unlawful character assassination. The defense has asked me to exclude these particular lyrics, poetry, words, speech, artistry from the indictment and exclusion from testimony and evidence pursuant to 24-4-401.
I sort of agree with the defense on this in the sense that rap lyrics, especially like drill and maybe these kind of lyrics, are considered they're inflammatory, you know. And you get some little old white housewife from the suburbs, and she starts hearing talk about pushing your shit back, boy, and you know whatever their lyrics are going to be. And if they're murderous lyrics, you know, talking about your ops, talking about whatever. It's gonna. I think it would shock the conscience of anybody who is not used to hearing this kind of stuff.
Mr. Williams, as well as others, have asked this court to further suppress any video, photographs, posts, or images that deal with these particular lyrics, words, speech, poetry, artistry, to be excluded from trial as well in total, and that these videos are protected speech as articulated by the same aforementioned provisions of the Georgia as well as U.S. Constitution. And as I mentioned, these arguments the court's going to apply as to all parties, not just the ones that argued yesterday, Mr. Steele, Mr. Sharp, and Mr. Weinstein. The court also, in considering this particular ruling, considered under the provisions of 24-1-104, which is the conditional admissibility or screening determination that this court may make.
One of the things you have to understand is that the judge's role here is that of a gatekeeper. You know, he calls balls and strikes and whatever, but he determines what evidence comes in and what doesn't. And there's a filter that comes through. It comes through the rules of evidence. So the judge has to look at everything. He has to make sure that it's relevant, it's material, and it's not more prejudicial than probative. It sounds more simple than it actually is, but that is essentially the guidepost that the judge goes by.
Which is, I believe, the drive, and D4, presented by Mr. Steele, and D4, which was the chart that Mr. Steele circulated for the courts and parties' consideration. So I've considered that universe of conditionally admissible evidence for my consideration on the ruling, on this particular ruling. The court has also further considered in making this ruling the commonality of specific lyrics as they relate to the issues of mens rea and actus reus.
So what's mens rea? State of mind. And what is, like the criminal intent, basically. And what is actus rea? The ability to carry, an act out. So the judge is going to rule here in a second, and he's looking at whether it applies to those two principles.
Also, the court has also considered that, depending upon the proof presented in this case, and that YSL, its and testimony that may be relevant of the gang's organization and/or strength would be relevant. The court has also considered that.
And remember, this isn't just a murder trial. This is a RICO trial, And so one of the things you have to prove up is an organization and acts in furtherance of the organization. When you have these lyrics, if they kind of establish who YSL is, and they talk about who YSL is in these lyrics and different activities of YSL, there you go.
These particular statements are being offered to show the elements of the offenses, and not the threat or conduct is not being prosecuted. But these particular lyrics can be associated with different things that the court mentioned that the state has proffered in States 19. As it pertains to the First Amendment assertions raised by Mr. Steele and Mr. Weinstein and Mr. Sharp under the First Amendment, the court has in fact considered Carpenter among other cases that were cited for the court's consideration yesterday, and that these lyrics, that rap lyrics are relevant,
and that the court must conduct a 403 balancing test, which it shall.
So what the defense's posture is here, there's a First Amendment privilege here, and you shouldn't, that shouldn't be abridged. And I don't think it really is.
In terms of the First Amendment analysis that Mr. Steele suggested I needed to conduct, I do have to conduct that, and I have conducted that in looking at the use of the statement, or is it being admitted for a proper purpose. I know that Mr. Steele argued very eloquently yesterday about it being character or improper character, propensity.
What that means is you can't have character evidence to show that somebody acted in conformity therewith. In other words, you can't say, well, he did it over here, so he's going to do it again. There's a different analysis for that.
It's not being admitted for improper characters that would fall under, the court would certainly screen it under certain other evidence standards. And the propensity argument that was made yesterday, this, as mentioned by the state, this evidence is not being admitted saying that Mr. Williams and any others did these things before, so they do them again. So I'm dissuaded as to the propensity argument. As it pertains to the issue of mental state, argued under 27-7-404B, expert witnesses, if qualified, may draw conclusions about intent as long as they don't state that this is the defendant's intent. So to Mr. Matthews, and your continued argument about that, and Mr. Steele as well, as long as those experts do not cross that particular line, those particular...
Because that's one of the problems here, is that you have other people who are going to be tried along with Young Thug, and if his lyrics are coming in and that's him singing, are you going to get painted with that same brush? That's what they're saying.
Things would be relevant. I've also considered United States versus Smith at 918 F. 3rd 825, that assuming a foundation can be laid, certainly, and if it's within this can of expert testimony, that certain terms or technology, or terms and or symbols or signs may be appropriate and relevant, giving meaning to gang determination.
You what he's saying there? Certain gang signs and certain cultural evidence that happens in the videos and in the lyrics are going to be admitted for the purpose of basically demonstrating the organization, YSL.
Through, I should say, 41 through 49 of states 18, 41 through 41 through 49 of states 18, submitted for the court's consideration yesterday. Those specific statements, the court will admit. I'll conditionally admit those pending lyrics, depending upon or subject to a foundation that is properly laid, that the conditional admission of these particular lyrics are proper. I would just ask the state, or just remind the state, if any other lyrics are sought to be admitted, that I'd have to go through this same analysis, and if you would do so.
So you can't just have somebody come in and testify about something. Yeah, they have to have specific knowledge that gives authenticity and certain indicia of reliability in order for the evidence to come in. That's what he's talking about. So, I mean, it's kind of boring in a way listening to a judge ramble on, and he's not really rambling on, he's giving a thorough analysis. But long and short of it is, a shit ton of his lyrics are coming in, and they're coming in against all 8 defendants. And those are not going to help the defense at all. So, a lot of developments going on, a lot of moving parts in this case. There's going to be another hearing on the 16th of this month. And that's when the judge is going to light a fire under the prosecutor. And we'll see if any of the evidence that they want to get in will be suppressed for lack of diligence on the state's part. So that's just our little YSL update. So appreciate you guys watching. Make sure you subscribe. Follow us on Instagram. Follow us on Twitter. Sign up for Patreon. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please just at my God.